of agreed judgment by uncontested notice by affidavit. We had previously sent them an affidavit and they just ignored it. I mean, I feel like that was brilliant from Sam. Anyway, this one was also certified. That was November 4th. What's today? The 11th. I checked it yesterday. It's stuck in Capel.
I don't understand it.
I don't know why I don't either.
I don't understand what you mean by stuff.
It's not getting to us.
Oh, okay, I got you.
It's not getting to them, and noticed it. So that's kind of where we are right now.
Well, I like that.
I like the title of
I
that.
like that
Yeah.
notice of agreed judgment by uncontested notice by affidavit.
Okay, and this is the part besides who it's going to, and it's from us. We are sending this to confirm that you never responded, therefore, you are in agreement, and we are all the rights as human beings. I don't like the word human, so I added a man and woman, who are, now listen to this part, who are Americans holding the positions of the entities doing business commerce. And that you have agreed that we are beneficiaries who also hold the position as the shareholders of stock as it relates to the United States entities or trusts. Interesting, huh? Now, Sam didn't go into a lot of explanation, but I know when Sam does something,
He's done research.
absolutely, and it has result. I don't see that they're going to be able to go anywhere with this. But that's kind of where it's hung right now.
Can I make a comment?
Huh?
Is it okay if I make a comment?
You want to make a comment?
Yeah. What's weird to me is that shareholders, being shareholders seems like it can be dangerous.
Well, I kind of thought about that, but why would Sam tell me to put that down?
Goes along with being the beneficiary
Yeah.
of the public trust.
But you can still be a beneficiary without having shares.
But this is
You can't be a shareholder.
shareholders of stock as it relates to the United States entities or trusts.
I don't know if you want to have anything to do with the United States.
That's what he said to put down.
The United States is the,
There's several United States, but I think you want to stay shy away from that. But Sam does his homework, so
It's too late. Bring him in.
okay.
We'll see what happens.
That was good. I appreciate you. You want to take any other questions from anyone else?
Well, I don't know how to respond to it because
Yeah, it's all.
we haven't gotten anything back.
we suspect that the document is stuck in Capel
It means they didn't want to get served, or they didn't want to get.
because the clerk changed the zip code right in front of her.
Yeah, that's right.
There you go.
Yeah. we changed
That's,
it.
Steve, got a question for her about
That's
anything?
defacing, you.
It's a federal offense. Now that is mail fraud.
Yeah.
You can go back and get her for that. Glenn, you got ready down?
Some reason it's
Oh.
not.
Will you help us get the screen?
It's there.
Glenn, you're the engineer. Well, but you got.
It's there.
It's not getting the signal.
Yeah, because that H3, I think it's for the TV. Is for
The NFC is loaded. Speaking of
There's only
overreactions,
two
let's
active.
do something with the
Right.
So second port. We had it earlier.
Yeah, we did. It's working.
You got to turn it off and back on. Maybe pick it up then.
I don't think so. Have you checked the cable is connected?
Yeah. Well.
It could be loose up there.
It's working now.
that's the input. I disconnect it, and that will disappear. You see?
Right.
And I connect it,
Right.
and it appears. So that's the only two inputs that are. You see? There. Let me turn it off.
Chargers, like what? They're 3-0 in the division. I understand their O-line stuff, but they voted.
Yeah, why would you need healthy O linemen? They're overrated.
No, they'll get. Harbaugh's gonna foul them. Might have been written before the Charger game. Respect.
The last time we saw the Chiefs too, like they were struggling as well.
Yeah, O-line.
The Bills,
Yeah.
and we saw the Bills struggling. So a lot of it, I think, like you.
Would it say if the connection's loose on the
Make
cable
it,
up there?
let me check. You're good. You're good. Let me just check. It looks okay here. There. Yeah, it's a cable, but it's working out. But it's the cable.
Okay, so you probably need to keep it that same one. It's on what, 4 now?
It's 3. It's
Well, it
3.
was-
It's 2. It's 2.
Yeah, but
It's
it's
the
cable. The
It's the
cable's
cable.
lousy
Just move
cable.
it, yeah.
I have to bring her a cable next time.
Okay, well, Glenn's going to talk to us about the Republic of Texas and how it still is in existence right now. So everybody give a good hand for Glenn.
Okay, so this is part of my lawsuit, actually. We're preparing a lawsuit against these military police. So anyways, I'm not going to go through the whole lawsuit. It's actually about 92 pages right now. So, but this is the history. So President Andrew Jackson officially recognized the Republic of Texas on March 3rd, 1837, which was also recognized by France December 25th, 1839, and other nations, including Belgium and the United Kingdom. And the demandant, that's me, has visited the former embassy of the Republic of Texas in Paris. I was there. I took pictures of it. I talked to the guy. It's now a hotel, but it's got the Republic of Texas on the outside of the building. It's engraved in the building, and it's down the street from the French Department of Justice. And
French?
yeah, Department of Justice, yeah, for France. Anyways, in the year 1845, the state of Texas joined the Confederacy and Union under the Articles of Confederation. Okay, now, when I took a U.S. history class in college, and one of the things they said is that they locked the doors during the Constitutional Convention because it was alleged that they were engaged in treason by having that Constitutional Convention, that the Constitution replaced the Articles of Confederation. And I don't believe that was true. I think that the Constitution is in addition to the Articles of Confederation, and the Articles of Confederation are still in full force and effect today. And the reason I say that is that they brought Texas into the Union under the Articles of Confederation in 1845. And it says HJR 1, 29th of December, 1845. The territory properly including within and rightfully belonging to the Republic of Texas was erected into a new state to be called the state of Texas. So that on an equal footing with the original states in all respects, whatever, with the Republican form of government. Okay, so this is all found in this Act of Congress at 9 Stat 1, and also in HJR 1, 29th of December, 1845. So this is the preamble to the Act of Congress at 9 Stat 1. So be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled that all the laws of the United States is hereby declared to extend to and over and to have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and Union of the United States. And then this is the House Joint Resolution, 29th of December, 1845 at 9 Stat 108. So it says, whereas Congress of the United States by a joint resolution approved March the 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the state of Texas, with a Republican form of government. And it goes on, it says, at the end, resolved that the Senate and House of Representatives of the United States of America and Congress assembled that the state of Texas shall be one and is hereby declared to be one of the United States of America and admitted into the Union on an equal footing with the original states in all respects whatever. When they're talking the original states, they're talking about the original 13 states, right? Under the definitive Treaty of Peace of 1783. And so, because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted, but was shelved. The state of Texas was created under the Articles of Confederation and Perpetual Union of 1781, Article 9. And it says here, Canada acceding to this confederation and joining in the measures the United States shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed to by 9 states, which means a House Joint Resolution. Think about it. That's the Articles of Confederation, 1781, which means the House Joint Resolution is all that was used. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas. The territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced with the state of Texas. And the Republic of Texas still existed, but was in dormancy or abeyance. In the year 1861, the Southern states walked out of Congress, and Congress ceased to have a quorum to conduct business and could not conduct business. And on the 15th of April, get a load of that date, 15th of April of 1861, Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 at 12 Stat 1258, and they've been operating under executive authority ever since. Now, just let me take a look at the YouTube.
Which is not a republic.
And it's not, you're right. We'll go into that here right now. The southern states that walked out of Congress became the Confederate States of America, and the war between the states was started, which eventually ended with an armistice, okay, which is a ceasefire only. All of those people are now dead, and there has never been a treaty of peace. The state of Texas was one of the Confederate States of America, and a technical state of war still exists between the United States and the Confederate States of America because there has been no treaty of peace, but there was an armistice, which is a ceasefire only. In the year 1863, Lincoln asked Harvard law professor Francis Lieber to write the law of war for the U.S. Army, which became known as the Lieber Code, but is actually designated General Orders 100, all of which is now included in the United States Law of War Manual. And I didn't bring that, but it's about that thick. That is now a book about 4 inches thick and is part of international law or the law of nations. The current state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code, and says a place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. The fact that you got troops on the street, you're under martial law. Yep. The martial law continues to this day under Article 2 of General Orders 100, Lieber Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by a special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond conclusion of peace as one of the conditions of the same. Because there has been no special proclamations by the Commander-in-Chief, who would be the President of the United States, and there is no treaty of peace to this date. In the year 1871, while operating under executive authority, Congress authorized a municipal corporation to operate in the District of Columbia at 16 Stat 419, which is talked about in the dissenting opinion of Downs versus Bidwell, U.S. Supreme Court, 1901, as the second national government that's maintained by Congress outside and independently of that instrument. And that instrument is the Constitution that they're talking about. And this is the site. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And that's the dissenting opinion of Justice Marshall Harlan. That the military police are conspiring together with the bar member handlers to work for it. An officer who acts in violation of the Constitution ceases to represent the government. In violation of their oaths to support and defend the supreme law of the land in Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So, the Republic of Texas, the 1933 Montevideo Convention on the Rights and Duties of States was ratified by the United States as a treaty. It's in the treaty collection. Okay, if you go to the treaty collection, it's there, which requires that recognition is irrevocable. Okay, once the Republic of Texas was revoked, they can't all of a sudden unrecognize it, especially when you point out that it still exists. It was not replaced by the state of Texas. And no state has the right to interfere in the internal or external affairs of another state. And further evidence of the war crimes being engaged by these military police in conspiracy with their bar member handlers to threaten, coerce, injure, intimidate the people of the Republic of Texas and the free exercise of our rights to engage in U.S. constitutionally protected activities of common law courts and petitioning the government for a redress of grievance in support of our right to self-determination and our right to determine our own political status as Texas nationals, violating the International Covenant on Civil and Political Rights, which was also ratified as a treaty entering into force on September 8th of 1992. Under House Joint Resolution 1, dated 29th of December, 1845, at 9 Stat 108, the state of Texas is required to have a Republican form of government. And it is impossible for a military government operating under martial law to be a Republican form of government because the military government is a dictatorship, as evidenced by Article 3 of the General Orders 100 Libra Code. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as in the dictation of general laws. That's dictatorship, folks. As far as military necessity requires the suspension, substitution, or dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue, either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. They don't want you knowing that you're under a dictatorship, okay? The War of Independence was fought because of a dictatorship, okay? So they don't want you knowing that they want you to think everything's normal, nothing's changed, okay? That's the first thing they're going to be telling you, but it has, because the troops are on the street. Okay, you see them every day in these military police cars. These are all military police. And because of a Republican form of government requires law of the land and common law and political power to be in the hands of we the people, and a symbolic military government called a democracy, with all state of Texas employees, including all the wrongdoers named herein being federal personnel, as required by the Roman civil codes, 5 U.S.C. 552A 13, which is anybody with a social security number. The term federal personnel means officers, employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. Anybody that's got a Social Security number is quote unquote federal personnel. And their 1871 municipal corporation has 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action whichever the particular nation, commonwealth, or city has peculiarly established peculiarly for itself, more properly called municipal law. So they're all municipal corporations. That exists today is the second national government talked about in the dissenting opinion of Downs versus Bidwell that's maintained by Congress outside and independently of that instrument, the Constitution, is a military dictatorship, and the United States has failed to provide a Republican form of government as required by Article 4, Section 4. The United States shall guarantee to every state in this union a Republican form of government, except that the Republic of Texas is the Republican form of government, but is being maliciously attacked by the scream for low intelligence, military police, and conspiracy with their bar member handlers. And you know that all police, that's one of the things I cover at the very beginning of this, is all police are screened for low intelligence and a propensity for aggressive behavior. Now, there's a case called versus City of New London. I talk about it up at the very beginning. 28. It's well established that military police officers like Casey Brashear, Andrea Brandt, Marshall Thomas, Captain M. Lugo, and Bobby LaPena are screened for low intelligence and a propensity for aggressive behavior. See Jordan versus City of New London, U.S. Court of Appeals for the Second Circuit. So what happened is a guy by the name of Robert Jordan had a master's degree, and they refused to hire him to be a police officer, so he sued them. And then went to the Second Court of Appeals in New York, and they said they can do that if they want, okay? So they don't want anybody with intelligence doing that job, okay? That's the important thing you understand.
Gotta have dumb people.
Well, they want hired thugs. Literally just a bunch of hired thugs.
Street gang with a gun.
That's what I put in here, okay? Anyways, so... after the wars between the states and its armistice, many years have passed, and all those involved on both sides are now dead. And in the early 1990s, some of the people of Texas, after reviewing the Act of Congress of 9 Stat 1 and the resolutions at HJR 8, March 5, 1845, 5 Stat 797, and HJR 1, 29th of December 1845 at 9 Stat 108 of the U.S. Congress and other historical evidence, discovered the Republic of Texas was in abeyance or dormancy, as an entirely different entity from the state of Texas, and the Texas territory is properly included within and rightfully belonging to the Republic of Texas, brought the Republic of Texas out of abeyance, which is dormancy, and organized the provisional government of the Republic of Texas and peacefully held elections and have been peacefully holding elections ever since to peacefully provide common law remedies for the people of Texas. In the year 1995, the Supreme Court of Texas dismissed a case involving the people of the Republic of Texas for lack of jurisdiction. Case 95-10002, 1002, styled In Re the People of the Republic of Texas by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District et al., evidencing that they have no authority over the people of the Republic of Texas. The U.S. Congress and President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, and is now the supreme law of the land as a treaty under Article 6, Clause 2, and we, the people of the Republic of Texas, have the right to self-determination and the right to determine our own political status as Texas nationals Therefore, we are engaging in U.S. constitutionally protected activity, and the military police are conspiring together with their bar member handlers to threaten, coerce, intimidate, and injure we the people of the Republic of Texas in the free exercise of our right to self-determination to determine our own political status as Texas nationals for our Republican form of government guaranteed under Article 4, Section 4. Anyway, so I kind of started going into it. Oh, yeah, this is good here. The defendant has never in his life breached the peace, but the military police breach the peace on a routine basis with their unlawful false arrests, false imprisonments, kidnappings as described herein. They've slandered and defamed the defendant in countless ways as described herein, demonstrate they want to demand anybody who thinks they have common law rights dead, because they're doing exactly what Lieutenant General Michael Flynn, U.S. Army, retired, says the U.S. Army does to an enemy in his book, The Citizen's Guide of Fifth Generation Warfare, Section 1 and Section 3-3. First, they polarize the enemy. Second, they tribalize the enemy. Third, they dehumanize the enemy. And finally, fourth, they kill the enemy, which was their objective for the defendant. They intend to murder the defendant. They have slandered the defendant, defamed the defendant, dehumanized the defendant, called him a sovereign citizen for their bar member handlers to the point his own sons and daughters do not talk to the defendant for fear of being slandered and defamed themselves. And these military police and their bar member handlers have demonstrated they intend to continue the slander and defamation to create terrorists so they can shed some innocent blood for their handlers and justify the defendant's murder until the defendant does turn up dead for their handlers. Anyways, I kind of go into a little bit of a rail here. So, anyways, that's about the Republic of Texas. That's the only part I wanted to cover today because the Republic of Texas is legitimate. It's treaty law. They recognized it. They can't unrecognize it. It exists. And we, the people, that's our common law jurisdiction here today. And that's the state of Texas is a military dictatorship, and it will never, ever be a Republican form of government. And that's one of the things I say in here. It can't be. It's impossible. It will never be a Republican form of government because it's a military dictatorship. Anyways, don't get me going. Let's see what the chat says in YouTube.
Why not? Why not get you going?
Yeah. So I'm just looking at the chat here, and there's nothing in there that's particularly interesting. People making statements, but that's fine, and I don't have a problem with people making statements. So anyways, that's all I wanted to cover today. Does anybody have any questions?
Where is that? Where can I get a copy of that?
This is going to be my lawsuit. Okay, I'm preparing a lawsuit that I'm going to file against these military police. I was telling Lucy about it here earlier because she was attacked by these, we'll be nice to them. They're military police. Anyways, so was several people in this room. And so hopefully we're going to break it off in their ass. Randy Kelton, when he saw my stuff, he called it word salad. He called it word salad because he didn't understand it at first. Okay, that's the thing, is he didn't understand it at first. And after he had a chance to read it, he told me to get O'Connor's causes of action and O'Connor's civil trials and use the stuff in those books. He said, because he said, you are bringing up stuff that they don't have a clue about. And if you do this right, you're going to break it off in their ass in such a way that they'll never forget it.
I don't even think the judges understand it, but this will give them a chance to look it up themselves.
Yeah, I agree.
But they won't look it up because
because they would also be committing a crime.
I've done the work for them here. And matter of fact, that's one of the things I'm doing is I'm suing the Secretary of State because I think that I'm asking for at the very end, I asked for a declaratory judgment, among other things, for a declaratory judgment that the Republic of Texas exists and that the the officers of the government of the Republic of Texas are entitled to diplomatic immunity under international law, and so which will be, you know, like the president, the vice president, officers of the. I was in charge of the affairs, and people like that. Okay, it's only certain officers that are entitled to diplomatic immunity, but if they recognize, if they bring back or reaffirm the recognition, then all of us, they're going to see us and turn and run the other direction. You put a Republic of Texas plate, they're going to leave you alone, you know, because I've been harassed about this stuff. I mean, there's all sorts of stuff that's gone on with me since 2007. They got an intelligence bulletin out there saying I'm armed and dangerous. Or they're straw man. Actually, it's the straw man that's armed and dangerous, and I go through that in here. But anyways, so the point is that it's war crimes. I had a judge in Dallas that I filed a war crimes complaint into an old case that got dismissed because I didn't pay the filing fee, and the judge in Dallas sent me an order of deficiency and told me I had to file a lawsuit. So they want it. I'm telling you, they want it. And I just filed a petition for writ of certiorari to the Supreme Court of the United States, and they haven't sent it back yet. And I'm thinking, I think they want it, okay? And the reason is I'm saying that the 1871 Corporation, that minor estate, and the bar, the National Bar Foundation, are unconstitutional because it's all coming from the Pope. And the First Amendment says Congress shall make no law respecting an establishment of religion. And so, and that's right with the Supreme Court right now, and they haven't sent it back. I think they want it. I wouldn't be surprised to get a docketing letter here pretty soon. And I'm sending it as an emergency petition. And that's the stuff they want, okay? They want that stuff because that's going to have national effect. That'll affect everybody in this country. And that's what they want. It's, you read their rules and they talk about that. That's the stuff that has that's huge repercussions, you know. And so and I filed that thing. I sent it the second time. The first time I sent it, they sent it back and they said that I needed to go through the appeal process. But I was, okay, under their codes. If you're in the Court of Appeals, you can bring an emergency petition to the Supreme Court anytime you're in the Court of Appeals before they issue judgment. And I'm in the Court of Appeals. It's case 25-103, 10380, I think. Anyways, it's in the Court of Appeals for the Fifth Circuit right now, and I'm bringing an emergency petition to the Supreme Court. And so, you know, we'll see what happens. You know, I don't know. I have no crystal ball. I have no idea how they're going to rule. But I think they want it. I think they almost have to rule that this thing is all unconstitutional because it's clearly coming from the Vatican. I show them how it's coming from the Vatican. And
also they can't rule against you because they know you're not getting a Republican form of government.
Well,
it's guaranteed.
I haven't even brought up that issue. Okay, I'm just bringing up the fact that it's coming from the Pope. But one of the things I brought up in here, okay, is the warrants. That's how come they dismissed my case, is because the warrants were not authentic, okay? Under the Authentications Act, which was the first act of Congress passed in the second session, okay? Matter of fact, I'll pull that up here. So first off, let me see here. There we go. Under the Authentications Act, right here, at 1 Stat 122, which is the first act of Congress in the second session, they passed an Authentications Act, and it said for any state to recognize the judicial proceedings of another state, it has to have a judge's signature and a court seal on it, okay? And those warrants that they arrested me on didn't have a court seal, so they're not authentic, okay? Therefore, they're a fraud. And I was unlawfully arrested. They went and assigned me a court-appointed attorney that was wanting to plea bargain my matter. And so I said, sure, no problem, you can plea bargain it. And I sent her 2 letters. The first letter was a motion for an identity hearing and an affidavit of fact explaining that I've been involved with the Republic of Texas for 20 years, and we were holding common law courts. Basically, what's called confession and avoidance. In other words, they're accusing me of organized criminal activity and being a terrorist, and I'm saying that I'm Republic of Texas and we had every right to do what we're doing. So it's confession and avoidance. And so what happened? Then I also said I want a identity hearing to show that I'm not a trust, that I'm not lost at sea. And then the second letter I sent her, I did a motion to quash the warrants because they're not authentic. And I said, if the warrants fail to be authentic, then they're fraud, and the rest was unlawful and illegal, and which means everything that precipitated from it is unlawful and illegal, and this case should be dismissed. The lawyer shows up 2 weeks later after I sent that letter out, and she says the case has been dismissed. All the charges, 3 felonies, have been dismissed. And so what happens, if you understand what goes on, when you challenge a warrant, then the arrest is presumed to be unlawful, and the burden's on the cop to prove that he made a lawful arrest. And if those warrants are not authentic, then it's clearly an unlawful arrest. That's why they dismissed it. I can just about guarantee. I'll bet you that lawyer went and told him that. The lawyer didn't tell me why it got dismissed. The lawyer just told me it got dismissed. I was released the next day, and so that's all in here, but I don't want to go into that right now. But that's what happened. Okay, I guess we could if we want. We got time. What time is it?
Ask him for money, because if you were.
It's only 1:07.
Yeah, right. Still pretty early. Let's go there.
What are you talking about? 2 different lawsuits?
No, one. I'm talking about one lawsuit right now. I have another lawsuit that is in the U.S. Court of Appeals and the Supreme Court. That's a separate one. Okay, this one has to be filed yet. Okay. There we go. On August the 4th, about 9 p.m., I was arrested by 5 cars of the New Mexico State Police in the parking lot of the Crown Plaza Hotel in Albuquerque, New Mexico. After returning with a friend from dinner, I was at an extraordinary science conference that I've gone to in early August for the last 7 to 8 years. I asked to see the warrant, always asked to see the warrant, tell them you want to see the warrant. And they failed to produce it. And I was in the backseat of the police cruiser and heard the officer say, tell someone I need that warrant. Well, that means they didn't have it. Okay, it was a computer entry. Okay, I'm going to break that off in their ass.
Good, they need to.
This is evidence of the weaponized Federal Bureau of Investigation and Texas Department of Public Safety and military police intended that the demanded exercise his right to resist their unlawful arrest. Citizens may resist an unlawful arrest to the point of taking the arresting officer's life if necessary. An illegal arrest is an assault and battery. The person so attempted of being restrained in his liberty has a right to use force and defending himself as he would in repelling any other assault and battery. Every person has a right to resist an unlawful arrest. In such a case, the person attempting an arrest standing in a position of a wrongdoer may be resisted with the use of force as in self-defense. There's a case called the Amistad. I don't know how many of you have heard about that case. It's a slave ship. And the slaves overpowered their captors and killed them all, except for 2 because they didn't know how to sail. And they said, take us back to Africa. And what they did was they sailed in circles off the coast of Virginia until the U.S. Navy found them. They brought them back. They charged them with murder. It went all the way to the Supreme Court. The Supreme Court dismissed the murder charges and ordered them sent back to Africa. So you have a right. The special deputy is bound to show the warrant if requested to do so, and if he omits, does not, the party against whom the warrant issued may resist an arrest, and the warrant under such circumstances is no protection against an action for an assault, battery, and false imprisonment. It is doubtless the duty of an officer who executes a warrant of arrest to state the nature and cause and the substance and cause of the charging process, which gives him the authority he professes to exercise, and if it is demanded, to exhibit his warrant, that the party arrested may have no excuse for resistance. And the New Mexico State Military Police would have an excuse to murder the demandant if he exercised his right to resist their unlawful arrest with lethal force if necessary, so the military police could shed some innocent blood for their handlers. And they could all justify the existence of the Joint Terrorism Task Force and say the Joint Terrorism Task Force is doing their job to kill a sovereign citizen terrorist, and the demandant would be dead, and who's going to say otherwise? This is evidence of their illegal search and seizure of the demandant's property and their government's hearsay database, and conspiracy with Casey Brashear because he knew where the demandant was because of the license plate on the car he was traveling in. If the record does not show upon its face the facts necessary to give jurisdiction, they will presume not to have existed. So anyways, I accuse him of attempted murder. So what else? There's some other stuff
What
too.
did they arrest you for then?
Sorry?
What was you arrested for then in New Mexico?
The 3 felonies that we talked about a minute
It
ago.
was, is it okay if I tell them what it is?
It was
engaging in organized criminal act.
yeah, an organized criminal activity and terrorism and terroristic threat. Why?
I'd just like to know.
Well, it's really none of your damn business, is it? There was some other stuff here that talked about unlawful arrests. I'm just trying to think of how I can find it, because that's all stuff that there we go. There we go. This is what I was looking for. First of all, it's malicious, okay? Because although probable cause may be inferred, may not be inferred from malice, malice may be inferred from lack of probable cause. And they didn't have probable cause because the arrests were void, okay? The warrants were not authentic, which means they didn't have probable cause, you know, and all the rest of it. The only thing the plaintiff needs to do is to allege a false arrest is either that the defendant made an arrest or imprisonment, or that the defendant affirmatively instigated, encouraged, or incited and caused the arrest or imprisonment. When the plaintiff is shown he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant to show that the arrest was made by authority of law. Any arrest made without a proper warrant signed by a judge, backed up by an affidavit of 2 persons that states under penalty of perjury you've broken a contract or hurt somebody, if challenged by the defendant, is presumptively invalid. Burdens upon the state to justify it as authorized by statute and does not validate the constitutional provisions or human rights. So remember, the supreme law of the land, okay, has to be authentic warrant. And I don't care what their state statutes say. If you go and look, Randy Kelton goes on their state statutes, and their state statutes say it doesn't necessarily have to have a court seal. But the supreme law of the land says that it does, and notwithstanding any state law. Anyways, don't get me going. You're going to get me going. In the case of an illegal arrest, the officer must keep within the law at his peril. Anyways, those are the ones that I wanted to show. The point is that this is the lawsuit I'm preparing. It's like about 100 pages right now. And Randy's helping me with it. He told me that he would be glad to review it, but he's going to tear it up every time. And I said, that's okay. I'm interested in constructive criticism. I'm open to, so I appreciate it. So I'm sending it to him periodically, and I got those books that he wanted me to get. So I'm going through those books right now, and they're about that thick, and they're little. There's like 600, 700, 800 pages in each book. So there's a lot of stuff to go through. So it's going to take me some time, but yeah. So, anyways, I guess that's about it.
Another thing that's real important is that the sworn testimony was not signed by the parties that claim acts were done. You know what I'm saying? It was someone that just gave a summary.
I know.
And there never was.
Oh, there's all sorts
It's
of.
numerous things. But that's pretty critical too. You're gonna have two people that sign a sworn affidavit.
Yep. So, anyways, so I guess that's about it. Thanks everybody on YouTube for watching. This was a short one, 45 minutes.